Can a conservator make healthcare decisions? Have you ever wondered who makes healthcare decisions when someone can no longer do so themselves? This is a common concern, especially when it comes to elder law and conservatorships. The answer is that a conservator can indeed make healthcare decisions, but there are important details to consider. First, the authority of a conservator to make healthcare decisions depends on the type of conservatorship granted by the court. Some conservatorships are limited to managing financial matters, while others include personnel and healthcare decisions. When a conservator is appointed with the authority to make healthcare decisions, they can act on behalf of the individual, known as the conservatee, especially if the conservatee lacks the capacity to make informed choices about their medical care. In situations where a person is incapacitated, the court may grant the conservator the power to consent to or refuse medical treatment. This authority is typically based on medical advice and the known values and wishes of the conservatee. The conservator may need to make decisions about treatments, medications, living arrangements, and even psychiatric commitments in some cases. However, it is crucial to understand that a conservator's authority is not automatic or unlimited. The court must explicitly grant this power through a conservatorship order. This order may involve a conservatorship of the person, a conservatorship of the estate, or a combination of both, which includes medical decision-making powers. In some areas, special conservatorships may be created for individuals with specific conditions like dementia, allowing for tailored healthcare decision-making authority. It is also important to distinguish between a conservator and a healthcare representative. A healthcare representative, also known as a healthcare proxy or agent, is appointed through advance healthcare directives to make medical decisions. In contrast, a conservator is appointed by the court and may have broader responsibilities, including financial management. If both roles exist, conflicts can arise, but typically, the conservator's healthcare decision-making authority is defined by the court order. Practically speaking, conservators must act in good faith when making healthcare decisions. They should base their choices on medical advice and consider the conservatee's preferences as much as possible. Courts keep an eye on conservators to ensure that decisions are made in the best interest of the conservatee, protecting their rights and well-being. In summary, a conservator can make healthcare decisions if the court grants that authority, usually when the conservatee is unable to make informed decisions themselves. This authority is part of the conservatorship order and is exercised with judicial oversight to safeguard the conservatee's interests.